In Alaska, the rules are pretty clear that every parent has an obligation to support his or her child. There are no exceptions. It is not linked to anything. It's not linked to visitation. It's not linked to whether the other parent is behaving well or badly. It is linked to basically the income of the parent and how much time a parent spends with the child. So the two things that are important is the amount of time a parent spends with the child and the gross income a parent has.
The judge must order child support whenever the court makes a custody decision. This is required by federal and state laws. The child support is calculated using a specific formula that is based on your parenting plan. Child support is not optional. Child support cannot be waived. Children are entitled to support. The four child support calculations are called shared, primary, divided, and hybrid. These calculations are based on the schedule of where the children live. The judge will issue an order stating the amount and starting date for payments. The judge will determine the amount of child support owed according to Civil Rule 90.3. This rule explains how to calculate the amount. Only in very rare circumstances does the court allow a variation from the rule. The judge will not sign a child support order based on the parent's agreement to vary the support amount.
The idea is that child support will allow either parent to properly support the child or support the child as best as the two parents could together.
It's all in a formula. There are many formulas, and it's set out very clearly in Civil Rule 90.3.
There are some helpful tools to figure out the child support amount. For primary custody child support situations, you can use the CSSD online calculator. This will ask you questions about your income and do the math for you. For shared, divided, and hybrid custody situations, the court has forms that you can fill out online. After putting in information about both parents' incomes and the percentage of time each will have the children overnight in a year, the form will do the math for you. After the form's filled out electronically, you will need to print it out to file in court. For the specific calculations, you should look at Civil Rule 90.3. You can find the rule on the Alaska Court System website. The court system also has a booklet on how to calculate child support, which can be downloaded from the website. Both sides must provide the court with information about income as well as pay stubs, W-2s, and tax returns. The court needs to understand what your annual adjusted income is. This is your gross income minus allowable deductions from Civil Rule 90.3. Civil Rule 90.3 will guide you about what kinds of income and deductions are used in calculating child support. Income for child support purposes is not necessarily the same as income for tax purposes, and deductions for child support purposes do not equal deductions for tax purposes. In general, your income includes any and all wages, payments, and in-kind benefits that your employer supplies, such as housing and meals, plus the PFD if you receive it. Don't include need-based public benefit programs like SSI, ATAP, or TANF. As deductions include what you pay for federal taxes, Medicare and Social Security, union dues, mandatory retirement contributions, and child care costs. To find more complete information about what is considered income and what the deductions are for child support, read Rule 90.3 and its commentary on the court website. The website also provides information for those whose income varies from year to year and those who are self-employed. You will need to submit a child support guideline affidavit to the court, also called Form DR-305, along with your last 2 pay stubs, W-2s, and tax returns for the last 2 years. You can get a copy of the Child Support Affidavit Form DR-305 through the Family Law Self-Help Center website. Attach the child support paperwork to a complaint, answer, motion, or notice of filing. You need to make a copy for the other side and a copy for your own records. Remember, you must serve the other side, and you must also file a certificate of service with the court as proof that you have given the other side a copy of the documents. The court will make a decision and issue a child support order. The order will say who owes the support, the amount, and the starting date for payment. The Alaska Child Support Services Division, or CSSD, formerly called CSED, can collect and enforce child support orders issued by the court. CSSD is not automatically involved in your case unless one parent applies for their services or the parent who has physical custody of the children receives a public benefit. There are 2 ways someone can get a child support order: from the court or from CSSD. The court must issue support orders when it decides a custody arrangement and a divorce or dissolution with children involved or between unmarried parents. In addition, CSSD can issue an administrative child support order if parents have split up and one parent wants the other to provide support, but there is no court case. If there's a later court case that results in a child support order, the court order takes priority over a CSSD order. You have the right to know how much money the other parent makes. There are specific ways to learn this information through CSSD or in the discovery process in a court case. If there's a change in circumstances, a child support order can be changed either by the court or by CSSD, depending on who issued the child support order. The court can modify a support order based on 2 situations. First, if there's a 15% change in the amount of child support orders, this means that when you calculate support based on the current income of the parent who pays, it is 15% more or less than the current support order. Second, the court can change a support amount if there's been a change in the parenting plan that changes the number of overnights so that you now have a different type of arrangement. For example, from a shared custody situation to a primary custody situation.
If a person's income goes up, then the person receiving the child support may want to come back to the court and have it modified. If a person's income goes down, that person may want to go back to the court. The important thing is not to just, without a court order, change and then let years go by before you go to court. The people need to go back and change the child support order, either by agreement, stipulation to the court, or by a motion to the court.
If you think that the support amount should change, you can file a motion to modify child support. You can find details on how to ask for a change and how to learn about the other parent's income on the Family Law Self-Help Center website.